Good evening, this is Brass Tacks. Welcome to the show. I'm Zaka Jacob. Delhi Chief Minister Arvind Kejriwal was today granted bail by the Supreme Court. He's been in jail since March of 2024 with the brief interim where he was released, of course, on bail to campaign for the Lok Sabha elections in May. The bench of Justices Suryakant and Ujjwal Bhuyan was scathing on the CBI, saying that just because an accused is evasive in his or her replies does not mean that that is grounds for arrest. It also said that the only reason the CBI arrested Kejriwal was to ensure that he continued to remain in custody when it was clear that he was going to get bail in the ED case. But at the same time, the BJP is also latching on to the stringent conditions imposed on Arvind Kejriwal from performing his duties as Chief Minister. It is said that he cannot go to the Secretariat, that he cannot sign official files, that he cannot meet people on an official basis as Chief Minister. So, has the court drawn a line when it comes to personal liberties, personal freedoms, fundamental rights, which are on the one side weighed against accusations of corruption, howsoever grave they may be, even if they are under stringent provisions of the PMLA? Will this set a precedent? But first, the story.
ये भी आज सुप्रीम कोर्ट के ऑर्डर से साफ हो गया कि सीबीआई की गिरफ्तारी केवल और केवल एक इंश्योरेंस अरेस्ट थी। ईडी की जमानत से केजरीवाल जी बाहर आ जाएं, उनको रोकने के लिए।
अरविंद केजरीवाल को तुरंत चाहिए कि वो अपने पद से इस्तीफा दे दे।
All right, so while the Supreme Court has made it clear that Arvind Kejriwal cannot visit the Delhi Secretariat, he cannot sign any files in his official capacity as Chief Minister, the judgment was scathing on the CBI, the premier investigating agency, particularly the second judgment authored by Justice Ujjwal Bhuyan, pulling up the central agency, the handling of the investigation. And this is what I want to quote from the judgment. Not so long ago, the CBI was called a caged parrot. The CBI must ensure that perception of caged parrot is erased. Fail to understand the CBI's haste in arresting Kejriwal. CBI's arrest was to frustrate the bail granted to Kejriwal in the ED case. CBI moved only after it realized that Kejriwal was going to be granted bail in the Enforcement Directorate case. The timing of the CBI arrest raises suspicion. CBI cannot justify arrest on the grounds and continue detention on the grounds that an accused person is citing evasive replies. Accused has the right to remain silent and cannot be compelled to make a statement against himself. Deprivation of liberty, even for a single day, is one day too many. Belated arrest of the appellant by the CBI is unjustified. Continued incarceration of the appellant has become untenable. So the judgment, both the judges concurring in their decision that yes, there are grounds, there is merit to grant bail to Arvind Kejriwal, one of them going hammer and tongs at the manner of arrest of the Delhi Chief Minister by the CBI. Let's put this up to our guest, Pradeep Bhandari, national spokesperson of the BJP here in our studios, Rajat Sethi, political analyst joining us, Rashid Kidwai, author and senior journalist, Siddharth Sharma is spokesperson of the Aam Aadmi Party. He'll be joining us in a minute. Pradeep Bhandari, I just read out, it's scathing what the judgment has said about the CBI. Not so long ago, CBI was called a caged parrot. CBI must ensure perception of caged parrot is erased. Failed to understand CBI's haste in arresting Kejriwal. The only purpose of arresting Kejriwal by the CBI was to frustrate the bail that was to be granted. CBI moved in only after it knew that Kejriwal was to be granted bail in the ED case. Today, if I'm the director of the CBI, I'm the one who should be stepping down given the ton loads that the Supreme Court has really befallen on the CBI and the manner of its investigation in this case.
Absolutely not, Zaka. If I am the director of CBI, it is Mr. Arvind Kejriwal who has to step down because the order does not say so. Let us now look at what the reality is. There are two orders of the court, Zaka. I have the order of Mr. Justice Suryakant, in fact, the opinion of Mr. Justice Suryakant. You just read out the opinion of Mr. Justice Udyan Bham. So, what does the law say? The law says that if there are two differing opinions between the two judges, you will go to the order of the Supreme Court. This is the order of the Supreme Court. And let me read the order of the Supreme Court. The Supreme Court in its order in point number 2, where it acknowledges that there is a differing opinion on the functioning of the CBI between Justice Ujjal Bhuyan and Justice Suryakant, but there is an agreement that the legality of the arrest was absolutely legal. It was legal, not for the first time, but for the 4th time the Supreme Court has said that the arrest is legal. So the process of law that the investigative agency followed was correct. Now let's go forward. What does the order say? The order goes ahead and says that Mr. Arvind Kejriwal cannot visit the Chief Minister's office. Mr. Arvind Kejriwal cannot sign on the file. Mr. Arvind Kejriwal has to give a bail bond of 10 lakh rupees. And again, it quotes further the para number 47 of Justice Suryakant's order. Now, please allow me to read.
Pradeep, look at those pictures. Look at those pictures. He's out.
Mr. Lalu Prasad
No, one second. He's out.
So what?
He is still Chief Minister of Delhi.
So
he
what?
is going to campaign in Haryana. He is going to campaign in Delhi. One second, let me finish. Look at those pictures. Just look at those pictures.
Zaka.
He is going to campaign in Haryana. He is going to campaign in Delhi. I'm not saying that anybody has given Mr. Kejriwal a clean sheet. You and your government kept him in jail for the better part of the last 8 months. Today, the Supreme Court has said the CBI had no business arresting him.
Zaka,
please respond.
very humble disagreement. The Supreme Court has not said this. There are two
I
judges.
just read.
No, you read one of the judges.
CBI moved
you
in
read
after
one of the judges.
Kejriwal was
Zaka,
granted bail in
Zaka,
ED case.
who's
Timing
the judge?
of the arrest
Zaka, who's the
raises
judge?
suspicion.
Zaga, who's the judge? Please
The judge is Justice Ujjal Bhayan. First of all, these are two separate judgments, concurring judgments,
No,
not differing.
they don't concur on the working of CBI.
The concurrence is on granting bail to Mr. Kejriwal.
And the legality of the arrest.
Both judges have concurred on giving bail to Kejriwal. Now answer.
One second. The judges have not concurred on the opinion of the CBI which you are reading. So CBI's cage parrot is not the opinion of the Supreme Court of India. When two judges differ on what they perceive of the CBI, you cannot say that the Supreme Court has it.
Justice Ujjal Bhayan has said not so long ago CBI was called cage parrot. That was also the opinion of one judge.
No, that was
not the opinion of the entire judgment.
Absolutely.
No, that was the opinion of one judge.
Zaga, was it the opinion of Justice Suryakant? Did he agree with him?
Sir, this is a concurring judgment. As far as the matter of bail, for Arvind Kejriwal is concerned, both judges have agreed.
And also on the legality of arrest.
On the legality of arrest. Yes, both of them have said that there was no reason to arrest. Right? Number two. Yes. The difference is the separate judgment is the role of the CBI and the manner of arrest of the CBI. Yes, one judge has a different opinion. The other judge has a different opinion.
So we will not say that it's the opinion of the Supreme Court.
Aren't you concerned?
No. I'll tell you why.
You're not concerned.
I'll tell you why.
That one of the judges is saying timing of the arrest raises suspicion.
I'll tell you why.
CBI moved in only after Kejriwal was granted bail in ED case. CBI's arrest was to frustrate the bail granted to Kejriwal.
I'll tell you why.
You are not worried about it.
I'll tell you why. Because Justice Suryakant is also not worried about it. Who's sitting on the
the same Justice Suryakant gave him bail.
But Justice Suryakant did not question on the validity
Justice
of the CBI.
Suryakant gave him bail, saying triple test of bail has been successfully met.
Zaka, nobody is debating whether the bail should be given or not. You are saying that the functioning of the CBI.
Why was he kept in custody then?
Has the Supreme Court
Why
said,
was he kept in
has the
custody
Supreme Court
then?
said that the
Why
arrest is illegal?
was
I'll
he
tell you
kept
why.
in custody by the CBI
because at that
for the
time,
last few months? At that time?
As per the Supreme Court, as per the courts, when he applied for the bail, the bail was not granted.
ED case. One second. ED case came. He was going to get bail in ED case. Why did the CBI arrest him?
You asked the Supreme Court.
I'm asking you. I'm asking you.
You should know.
You are the spokesperson of the ruling party. I'm asking you, sir. Why did the CBI arrest? Court has today said only purpose of CBI to arrest Mr. Kejriwal was to frustrate the bail granted by Kejriwal. CBI moved in only after Kejriwal was granted bail in ED case.
That is one of the judges who said that Justice Suryakant did not agree with what you said.
This is the opinion of Justice Ujjal Bhayan.
But is it the opinion of Justice Suryakant? No. Justice Suryakant and Justice Ujjal agree on the legality of arrest.
Is CBI going to go back to a higher bench, a larger bench and say, oh, Justice Suryakant did not say this. Please put him back in jail. Are you telling me this?
Zaka,
anybody with elementary knowledge of law knows that both judges have concurred in
No,
the matter.
both
The matter.
no. Both judges
What
have
was
not
the matter?
concurred.
What was the matter?
Okay,
One
let
second.
us go.
What
Okay,
was the matter?
yeah, this is the
Matter was,
No.
should
Three.
Kejriwal be given
No,
bail or not?
No.
Was the matter,
No,
should
that was not.
Kejriwal,
No.
What was
There
the
were
matter?
three. I'll tell you.
What was the matter?
Open
No,
the
one
paragraph.
second. What was the
Open
matter?
Open the order.
What was the
I'll tell you.
matter
Three.
before the Supreme Court?
Three matters. Please
No.
read.
What was the fundamental case before the Supreme Court?
Okay, I'm reading it now. Allow me to read the Supreme Court. Please listen. Having considered the material on record and the extensive submission made by the parties, the following questions fall for a deliberation. Okay? Point number 1, whether there was any illegality in the appellant's arrest. That is one question. Point number 2, whether the arrest was lawful. Point number 2. Point number 3, is the appellant entitled to a bail? These are 3 points. What did the Supreme Court said on the legality of arrest? The Supreme Court said on the legality of arrest that it is an absolutely legal
CBI's arrest was to frustrate bail granted to Kejriwal. CBI moved in after Kejriwal was granted bail. CBI cannot justify arrest and continue detention, citing evasive replies. Accused has the right to remain silent and cannot be compelled to make statements against himself. This is what the court has said.
No, this is not the order.
And I reiterate, before I come to the guests,
10 seconds.
before I move to the other guests,
The appellant shall not make any public comments on the merits
CBI
of the CBI
director
case.
has
There
been
is no comment on the
slapped
merits of the
with
CBI
this
case.
judgment today,
No, that's not the judgment.
I'm sorry,
No,
the
that's not the
CBI
judgment.
director should step down. If
That's not the
anybody should
judgment.
step down,
That's
the
not the
CBI
judgment.
director has been completely
No.
taken to the cleaners today
No.
by Justice Ujjwal Bhoyan,
But
who
not
was
by
one of
Justice
two
Surya Kant.
judges who has granted bail to Mr. Kejriwal.
in
Now, Mr.
2000
Sharma. Now, Mr. Sharma. Mr. Sharma, let me take my good friend Mr. Bandari's point. Justice Surya Kant, on the legality or the illegality of the arrest, has said this, the following. Appellant's arrest by CBI was permissible in light of trial court's order dated June 25, 2024. Justice Surya Kant also says, do not find any merit in appellant's contention that CBI failed to comply with set procedures that are meant for arrest. Justice Surya Kant also says, appellant's arrest does not suffer from any procedural infirmity. Plea on non-compliance of procedure does not merit any acceptance by this court. This is one of the two judges who pronounced the order today, who is saying that the arrest was not wrong, the arrest was not illegal, and that whatever was cited by Mr. Kejriwal's lawyers was wrong, and the arrest was permissible in light of the trial court's order dated 25th June 2024. Mr. Sharma.
Then how come Zaka Arvind Kejriwal is out today?
It's bail.
Okay.
It's the norm, not the
okay.
exception.
Okay. Let me at the outset empathize today with Pradeep Bhandari. I think Zaka should have given him enough time. You were interrupting him too much. He would not get the flow. I think he had a point, and let the viewers should have listened to his point. However,
so
whatever his
AAP
points
and BJP have now joined hands. Okay, they're on the same page on this one. Okay.
No. As a debater, I would have liked to listen to what he said. Anyway, no point, no problem. What substantive thing happened today was that the Supreme Court today unambiguously told Modi Sarkar three things. One, this nation is governed by the Constitution and not by the delusion of BJP. Number two, CBI arrested Arvind Kejriwal illegally after the Supreme Court released him in an ED case. And number three, CBI and ED are caged parrots. Now, from these three observations, my logical question to BJP is, will now Modi 2.40, which is already on crutches, stop seeing power as a weapon to punish and start seeing power as a tool to serve? Point number two, when is the Home Minister, Mr. Amit Shah, resigning as owner of that caged parrot and the architect-in-chief of this entire conspiracy to jail an elected chief minister?
But Sharma Saab, I want to separate two or three issues. Let's separate two or three issues.
Can I complete my opening statement?
I can. Just give me 10 seconds. One of the judges has said that the manner of arrest was illegal. The other judge, as I read out, did not find merit in the illegality of the arrest. But both judges concurred, yes, there is merits for bail. One judge said the triple test of bail has been cleared, therefore bail is being given. The other judge also gave him bail, but the other judge had very, very big questions to ask about the manner of arrest. But the point is that to say that the arrest was illegal or to say that the central government misused the CBI, none of that has been cited in the judgment today.
Yeah, what this judgment has essentially ensured Zaka today, the byproduct of today's judgment will be that no common man or political party will get intimidated by BJP's hounding wolves anymore. That is a closed chapter now. ये जो ऑपरेशन कमल करते हैं, चाहे वो झारखंड में करे, चाहे अरविंद केजरीवाल के साथ करे, चाहे कर्नाटक में करे, चाहे महाराष्ट्र में करे, उस पर आज से ताला लग गया।
बट शर्मा साहब, ये तो सिर्फ बेल है। This is not a clean sheet. This is not a clean sheet. This is not a clean sheet.
10 seconds, Zaka. 10 seconds. This nation is blessed by Lord Ram. Arvind Kejriwal is loved by India, and the common man today has a shield called Constitution.
कोर्ट ने तो ये नहीं बोला ना कि अरविंद केजरीवाल को बरी कर दिया।
I'll come to that.
कोर्ट ने तो ये नहीं बोल दिया ना कि अरविंद केजरीवाल को एक्विट कर रहे हैं हम। उनका कोई रोल ही नहीं था लिकर गेट में।
नहीं, आज ये today the situation has come that Mr. Arvind Kejriwal and Mr. Himant Biswa Sharma, both chief ministers of the respective states, both accused under ED, both are under ED investigation, are both on the same footing. That is what has happened today.
Okay, so Arvind Kejriwal and Hemant Biswa are on the same footing. Also, ये भी तो बता दीजिए ना कि the court has also said he can't sign any files, he can't go to the secretariat, he can't do anything on official duty. इसके बारे में भी बोल दीजिए. Is that not an indictment?
No, absolutely not. Shall I give you a cheeky answer to that?
No, cheeky is fine.
Okay, cheekiest point is that if Mr. Narendra Modi can keep peace in Manipur without going to Manipur, if Mr. Narendra Modi sitting in India can stop the Russia-Ukraine war, if Mr. Narendra Modi without going to Switzerland can ensure 310 million
no court has said. No court has said Mr. Modi cannot go to Parliament. No court has said that he cannot go to South Block where his office is. But today a court has said Mr. Kejriwal cannot go to Secretariat. Mr. Kejriwal cannot sign official files. Court has said. ये कोर्ट ने बोला है, मैंने नहीं बोला है.
अरे झाका, लेट मी
आज के जजमेंट में है सर, पढ़ लीजिए.
जजमेंट सर हमने भी पढ़ा है. The court has not stopped Arvind Kejriwal from signing any papers. The court has only said he cannot go to the chief minister's office. And let me tell you.
No. One second. Let's be sir. Let's not mislead our viewers.
Let me complete.
Let's not mislead our viewers. Let's be true to facts. कोर्ट ने ये बोला है he cannot perform any official duties as chief minister, including signing files officially as chief minister. सर ये जजमेंट में है सर. सर ये जजमेंट में है.
No, he can sign. You are fighting wrong and you are misleading.
Pradeep Bhandari, quick response, and I go to Rajat Sethi and to Rashid Kidwai after that.
There was a time.
Pradeep was responding. Cheeky answer.
Zaka, there was a time when Lalu Prasad Yadav also used to think that he is the most honest politician of India, and he was also quote unquote out on bail. But then the law took its own course. Again, I am reiterating, no court has passed such harsh conditions on bail as has been passed on Mr. Arvind Kejriwal. He cannot visit the Chief Minister's office. He cannot sign a single fine without the concurrence of the Lieutenant Governor, which means that the court believes that Mr. Arvind Kejriwal is not fit to discharge his duties as the Delhi Chief Minister. But सत्ता का लोभ इतना है कि तब भी बने रहेंगे.
तो शर्मा साहब, very quickly, if he can't, शर्मा साहब ये बताइए ना, if he can't, शर्मा साहब ये सुन लीजिए, सवाल सुन लीजिए. If he can't sign files, if he can't go to secretariat, official capacity में कुछ कर नहीं सकते, तो इस्तीफा दे दें. क्या ही करना? मतलब.
Is that question to me?
Yeah, exactly, to you.
Yeah, I'll tell you, Zaka. I gave a cheeky answer earlier. That's because you asked me for. But the substantial part is that we should understand that unlike what the BJP deludedly thinks, that this nation is run by Mr. Modi by coming at 8 o'clock. If Mr. Modi can come at 8 o'clock in the night on national television on a studio and bring in demonetization or bring in a lockdown, Mr. Arvind Kejriwal, wherever he has been in the last 6 months, the electricity of Delhi, free electricity is going on, the free water is going on,
which by the way,
education is going on.
Both of these decisions,
Electricity cut होना चालू हो गई
sir. Challenged in court. Courts validated both of these decisions. Let's move aside.
Electricity cut होना चालू हो गई sir.
Let's go to Rajat Sethi. Rajat Sethi, there is one point which the BJP needs to address. That you cannot just randomly throw all opposition leaders. Hemant Soren was in jail, he got bail. Now in the liquor gate itself, from K. Kavita to Vijay Nair, Manish Sisodia, Mr. Mahindru, now Mr. Kejriwal, one after another have gotten bail because fundamentally the court has said you can't just incarcerate people and they have to wait for years for the trial to begin. That fundamental rights, right to life and liberty, trump over any stringent provision of PMLA. In number of cases, including in today's case, the court has reiterated that. Rajat.
Sorry, yeah.
You have to unmute,
I think while the court was pointing one finger at these agencies and the central government today, 4 were pointing towards itself. And let me tell you that PMLA has been under consideration with the Supreme Court. And what has the Supreme Court done for the past 4 or 5 years? Why have they not clamped down on absolutely unconstitutional origins of the PMLA itself? Why have they not gone ahead and taken steps on the bail plea before? Were they not justices? Is Justice Bhuyan actually accusing his colleagues who rejected the bail of Arvind Kejriwal repeatedly? Is he going against the Delhi High Court justices who rejected the bail as well? Should all these justices resign because their position was actually factually incorrect? If you hold that as the gospel truth from here onwards, what Justice Bhuyan said? What has the Supreme Court said in terms of laying down frameworks for bail which are not dependent on whether you are the chief minister or a common person on the streets of New Delhi? Tell me that.
I do want to clarify.
Let me complete
just
my
give
point.
me 10 seconds.
Allow my flow of thoughts to conclude.
Since you brought it.
Allow my flow of thoughts to conclude.
Okay, conclude. Yeah,
See, the point is right to equality and equal justice should have been guaranteed by none other than the Supreme Court. So if there is a common man on the street or the Prime Minister or anybody else for that matter, they should see bail as a norm for this country. Can the Supreme Court come out and say that from here onwards, bail will be the norm? And if they cannot, they should stop sermonizing. And I'm saying that with all and utmost respect.
I just want to clarify one point. When a related matter had come up about 3-4 months ago, if I'm not mistaken, if my memory serves me right, I think it was a bench headed by the CJI, Justice Chandrachud, who said that lower courts are erring when it comes to matters of bail, and that life and liberty, life and liberty, Rajat, please.
No.
Rajat, give me 10 seconds. No, let me. You asked for time. I allowed you to finish your point. Let me just conclude my thought in 10 seconds, please. Life and liberty. The judge. I mean, I think it was the CJI who said that life and liberty trumps over any alleged criminality, howsoever high the bar for bail might be, even as per Section 45 of PMLA. This is what the Supreme Court had said, and I believe all these bails for various accused in the liquor gate and other matters have sort of happened after that was said by the highest court.
In spite of Chief Justice's big bold words, it will be the Supreme Court yet again who will eat these words and not pass judgments on bail orders even in the future, no matter what the government of the day is. The real problem is that the bail norms should be laid out in black and white, and there should be no grey area whatsoever.
Let me move from.
You can come out and discuss about the morality.
Let me move from the legal to the political. Rashid Kidwai, what is going to be the political fallout of Arvind Kejriwal's release? Court has not put any restrictions on him taking part in political activity. Yes, his official duties, the court has put some restrictions on, but no bar on campaigning, no bar on going to Haryana and campaigning, no bar on campaigning in Delhi for the next assembly elections. How do you see this playing out over the next 6 months?
Yes, so Zaka, I think that's a very valid and a very pertinent question. I think today's, Arvind Kejriwal getting bail is a huge political setback to the BJP. The BJP spokesman is behaving as if he's a CBI spokesperson. He must do the cost, analysis of the implications, what you are raising, and how it is going to play out in Haryana and in coming Delhi elections, etc. The case should have been on the part of, CBI and others should have been watertight. If they were arrested, Mr. Arvind Kejriwal, they should have been able to book him. Supreme Court is not a trial court. The trial will take place. Mr. Arvind Kejriwal has roots in society. He is an elected representative. So therefore, if he had committed any wrong, he should have been punished. There should have been a strong case against him. Thing is, CBI is not a cage parrot. CBI acts like a vulture when it comes to opposition. I am not saying it, Zaka. This is not my word. This is in May 2013 when Supreme Court had originally coined this word, cage parrot. This was said by Mr. Anand Kumar, the General Secretary of the BJP. So the BJP has double yardsticks. When they were in opposition, they described CBI as a vulture when it comes to opposition.
Okay.
In 2024, 11 years later, the BJP spokesman is doubling up as a CBI spokesperson.
No, but Rashid, what is the political fallout? I'll give you 30 seconds to.
The political fallout is huge because now Mr. Arvind Kejriwal will campaign. He would stand as sort of politically vindicated. That is, he would say that there is no truth in this liquor scam. It was all Tota Maina ki kahani. It was all cooked up. All these things and it will reflect more Zaka more than Haryana. It will reflect very badly on the BJP in Delhi.
Okay, Haryana and Delhi. Quick response, Rashid. Sorry, Pradeep. I have to go to Dr. Singhvi.
See, I'll come on the politics of it, but I am spokesperson for truth, and the truth is that the order of the Supreme Court, as I reiterate, only speaks about the legality of arrest, grants a conditional bail. That's the fact. Now, Mr. Rashidji was speaking about the politics of it. On a lighter note, when Mr. Arvind Kejriwal had come out of on bail in the May order of the Supreme Court, he contested on 7 seats in Delhi. All the 7 seats were won by the Bharatiya Janata Party. He contested in Haryana and he could not win a single seat. In the last Haryana Assembly election, the Aam Aadmi Party lost deposits on all seats, including Bhiwani. So, in fact, I'll tell you, Zaka, the amount of happiness which is there in the studios, seeing Mr. Arvind Kejriwal's release, is not even there in the Congress Party, in Rahul Gandhi. Rahul Gandhi got even tweeted once. I want to ask you.
No, there's no happiness or anything. I think the court has reiterated a fundamental principle that right to life and liberty trumps over everything else.
Absolutely, but my question
is whatever alleged criminality there might be.
See, Zaka, you were speaking about the India Alliance. I remember doing a debate with you on the Haryana. But why has the Congress not tweeted about it?
Okay, I have to go to Dr. Singhvi. Thank you very much to all our guests. Thank you so much. Dr. Singhvi is multiple-term parliamentarian, member of the CWC, and in this context, most importantly, the lawyer for Mr. Arvind Kejriwal. Dr. Singhvi, thank you very much for speaking with us. There is a differing opinion. I don't know if you got a chance to hear our debate. Clearly, the BJP and its spokespeople have taken a different view. They have clung on to one of the two judges today, Judge Suryakant, who has said that there was no illegality in the arrest and that the appellant's arrest by the CBI was permissible in light of the trial court's order, that there was no merit in the appellant's contention that set procedure was flouted or that the arrest suffers from any kind of procedural infirmity. They are saying that at least one of two judges has said that yes, there was nothing wrong with the arrest. Yes, he's passed the triple test of bail, but that doesn't mean that the arrest was illegal.
Zaka, these are nuances which require some time without being technical, and I think your viewers need to know this. And you should not be surprised at the respective political views being taken. But let's leave politics aside for a while. Number one, the takeaway is a unanimous decision by both judges that bail is deserved, bail is the rule, tampering is not made out, flight risk is not there. There is no question of the trial being completed not in the foreseeable or even the longer future. It has not even started. The logistics are enormous, and delay defeats the fundamental rights of the accused and therefore trumps any objection to bail. These are all unanimous decisions of both, which people tend to forget. Number two, there is a nuance. Justice Suryakant, of course, has said that the arrest is valid. But Justice Suryakant has done that only on the basis of one basis, a legal basis. He has not examined the factual part. Legally, he has said that 41 and 41A2 provisions are inapplicable to the arrest for the simple reason that Kejriwal was already an arrestee in judicial custody. And therefore, the police didn't have to do those things. The magistrate did it. That's the short point he's dealt with. Now, I have genuine great respect for Justice Suryakant. He has not dealt with the other point, which the other judge has dealt with, on necessity to arrest. So I would say that this is an error here between the two. I would prefer the Bhuyan view for the reason that Justice Bhuyan says that forget everything else. Factually, the 3 dates show that a FIR of August 28, a interrogation of middle of 23, August 22, interrogation of middle of 23, and an arrest of March 24 cannot show a necessity to arrest. Now, the point which is the error here is that even assuming that Justice Suryakant is right about 41 and 41A not applying, it is possible for him to say that on these dates, the magistrate erred. And that is the basis on which Justice Bhuyan has given, I think, contextually a correct judgment. Number three is important. The conditions of bail, a lot of misinformation is going on. People tend to forget that these conditions are not at all new. They are identical to the 12th July order.
Yes.
Now, they also forget that Kejriwal holds no portfolio. Actually, Kejriwal is a unique chief minister who doesn't sign files because his portfolio ministers sign files. There is one category only which he has to sign, which are those for onward transmission to the LG. The Supreme Court on 12th July, forget today, has specifically permitted him to sign all those files which he needs to sign, which are the ones going on to the LG. So in that sense, it's a red herring to talk about governance even after he's out.
But tell me, Dr. Singhvi, tell me, Dr. Singhvi, when the court has said he can't visit the secretariat, he can't sign files officially, there is no discharge of duties in his official capacity as chief minister, the BJP is saying, why doesn't he just step down?
Can I? You didn't hear me out. You didn't allow me to complete. That's misreading and a missummary of the order. You are saying he can't sign files, he can't go to the secretary. He can sign all the files which are needed to be signed by him at your house, at my house, at his own house. He can. That category of files which he signs is specifically permitted by the Supreme Court, is the category which goes to the LG. Other files he doesn't sign anyway.
No, but if he can't discharge his official duties as Chief Minister of Delhi, then why is he clinging on to that chair? That's the question being asked by the BJP.
1 minute. Who is saying that he cannot discharge?
Well, he can't go to the secretariat. As you said, he's a no portfolios minister.
1 minute. Can he not take political decisions in the cabinet as the Chief Minister, where his portfolio minister signed the file? Can he take a decision? There was some fetter when he was in jail because possibly he could not talk politics and take decisions. Has the court said that as an elected CM today he cannot take a decision?
Okay, let me be clear about what you're saying. That Mr. Kejriwal, if he so chooses, tomorrow can call for a cabinet meeting of the Delhi cabinet in his house, take decisions, get his ministers to sign off on those files. Is that what you're saying?
To the extent that the allocation of powers allows the minister to sign, that minister will sign. The court cannot ever say, it cannot ever say and has never said that you are an elected CM and I will stop you and paralyze you without an electorate throwing you out. That's a complete misreading. Yes, what he cannot do is, he cannot sign files, most of which he could not and need not have signed anyway because the minister signed them.
What about those files, even if he were to sign it, have to be authorized by the LG?
Always. Even when he was free, even when there was no case, even when there was no liquor scam, even when he was not arrested. All files which go to the LG anyway go to the LG. The only addition is they require Kejriwal's signature and not the signature of ABC minister. The problem is that too much of politics clouds the detail, clouds the principle. Now this is today, in fact, when you're in jail, you can say physically, since your movements are circumscribed, there is some effect on governance, communication, movement around, meeting the people.
Okay.
Finding that your house is a drain which is leaking, finding my house is a tree which has fallen down and taking action. But today, there is no question that an order of 12th July of the Supreme Court, it would be ridiculous to suggest, says that Mr. Kejriwal cannot function, cannot take decisions.
Okay. I want to get one final question from you, which is basically that the implication of today's judgment is, and of course, Mr. Kejriwal is not the first person to get bail in this case. A number of people have got bail. And one recurring theme, almost like a leitmotif that we're seeing is that court is saying that right to life and liberty trump over any alleged criminality, howsoever high the bar may be, under 45 of PMLA. Number two, and I think this is I guess this has implications beyond just the Liquorgate scam, that you cannot incarcerate people without any definitive timeline for a trial. What may the implication of that be? Number of people the court has said while citing that as a reason to give them bail.
A number of Supreme Court decisions, many of which I've had the privilege of assisting the Supreme Court in, have now held that despite the higher negative threshold of Section 45 of the PMLA, the even higher threshold of the Constitution, which is even higher, Article 20, 21 and 22, right to life, will trump and override that negative threshold if you are able to show delay. Now in this so-called liquor scam, they have said that forget trial. Trial is not even started. There are lakhs of digital documents. There are thousands of non-digital documents. There are hundreds of witnesses. And that will trump the negative bar of 45. The second thing is important is that you are today, when this happened, Zaka, I was abroad. When the third week, June, arrest of CBI happened, I used the term insurance arrest, which I have used hundreds of times thereafter. The court has not adopted that term, though I argued it. But the court has said something similar as far as Justice Bhuyan is concerned. He says this is a strategic move to frustrate his impending release. 2, he had got release orders, and 1 he got later. So this is the only case where a person has 3 release orders under more stringent acts, and the CBI comes along and arrests him after 2 years. And last but not the least, you must actually thank the BJP. You must actually thank the ED in setting law. And I'll tell you why. The so-called fortress of PMLA, the so-called impregnable fortress of PMLA, has now actually become a hut, and even the walls of that hut are crumbling. Judgment after judgment in the last 2 years, because of the high-handedness of the ruling party, because of the misuse of ED against political opponents, has set a catena of about 10 to 12 judgments, which have now opened up the interpretation of the act, which was assumed to be impregnable.
Okay, but very quickly, do you believe the really strong words that Justice Bhuyan had for the CBI when it came to arrest will now raise the bar for arrest by investigative agencies?
Theoretically, yes. Practically, no.
Okay, all right.
When you have a vulture or a caged parrot, or you have any kind of a person who's under the direction and control, and especially of a control freak sarkar like this, I don't see any change in the ground. The Supreme Court speaks generally. You can always do something else on the ground till that case comes up next time in the Supreme Court.
Okay, Dr. Singhvi, as always, a pleasure speaking with you. Thank you very much for joining us and explaining to our viewers the import of today's judgment. Thank you.